So the topic today is e-commerce taxation in a post-South Dakota v. Wayfair world. I'll start with a little bit of some preliminaries that if you're not terribly familiar with the case, you're likely to have a question about. And then we'll move into some of the downstream ramifications of what e-commerce sellers have to think about now with respect to maintaining their tax compliance. Okay, sound good? All right. Here's a little bit about Somos. Now, I don't think the Magento folks have my slide deck. So if anybody wants a copy of the slide deck, come down to the Somos booth. We're around here, I don't know where, somewhere, and give me your business card, and I'll be happy to send you one because I have a lot of charts in here with a lot of states' names on them. So if you want to have this as a reference point, just let me know. I'm happy to share it. All right. Question number one, what exactly did the Supreme Court do in South Dakota v. Wayfair? So to answer that question, you need a very, very, very brief history lesson, and I'll keep it brief. So back in 1992, the Supreme Court decided a case called Quill versus North Dakota. Are the folks in here familiar with Quill versus North Dakota? All right, great. So essentially what Quill said, what the court said in Quill, essentially they were affirming a decision from back in 1968. And what the court said was that in order to compel a seller to collect and remit your state and local sales tax, that seller had to be physically present in the jurisdiction. In other words, they said that it was an undue burden on interstate commerce to impose that kind of requirement unless the seller was actually there in the jurisdiction, meaning they had people, like employees, or they had property, like a building or inventory or something like that. And that was the rule from the 1960s, affirmed in 1992, all the way until very recently. And of course, everybody knows that in those intervening 20, 30, 40 years, the world of e-commerce grew up around it, and states were really chomping at the bit trying to get access to more sales tax revenue, to get the money that was now not being spent over the counter, but was being spent online to fund their governments. So a bunch of things were tried over the years, some of which were moderately successful, but essentially in 2016, the state of South Dakota, a relatively small population center inside the United States, I don't know if anybody's from South Dakota in the audience, essentially what they did was they made a direct attack at the Quill doctrine. And they passed a law, and that law said you're obligated to collect tax in South Dakota, not based on your physical presence, but based on whether you have $100,000 in sales or you engage in 200 or more separate transactions in the jurisdiction. So pretty small numbers, right? That you don't have to be too big of a business to hit those thresholds, but of course South Dakota is a relatively small population center. So when they passed that law, as expected, a bunch of sellers, Wayfair, Overstock, Newegg, challenged that statute as being unconstitutional, and when they did, they essentially set themselves up for a battle in front of the US Supreme Court that every sales tax nerd in the country has been waiting for the better part of their lives, including me. So the case finally got to the Supreme Court, and just last June, the court rendered a decision, and what they said was that the previous cases were wrongly decided. They misinterpreted the United States Constitution, and what the court now says is that physical presence isn't necessarily a good proxy for determining whether it's fair or not fair to impose sales tax obligations on a seller, and that states have the ability to enact rules that don't depend on it. In other words, what they said was in South Dakota, pretty much, they didn't say it outright, but they pretty much said, you know, through the subtext of the opinion, that South Dakota has a pretty simple sales tax law. They're a member of the Streamlined Sales Tax Governing Board, which we'll talk about a little bit later, and their rule excludes the smallest sellers, meaning it doesn't create a burden for those people that aren't able to comply. And essentially what they said was that, okay, that type of standard passes the test, even though it's not one based on physical presence, and it's constitutional. So what we saw after that, amazing. We'll talk a little bit about that. So that particular law only, of course, impacted South Dakota. And right now, actually, that case was sent back to the lower courts, and they're still figuring it out in South Dakota. But South Dakota is about to go live with their Economic Nexus statute. But what we've seen since that time has been unprecedented in state politics. Since June, a bunch of states have moved to enact rules that are exactly like South Dakota, or reasonably approximate to what South Dakota has tried to do. So there are these bunch of states that had these laws on the books. They said, you know what, we don't want to get into the legal fight, but the minute the legal fight is settled, we want to start taxing internet commerce. We want to make sure that we get our share of the tax dollars that spring from e-commerce. So states like Hawaii and Maine and Vermont, they all had stuff ready to go on their books that immediately went into effect after the Wayfair decision was decided. But then what we saw, even though it was the summertime and a lot of state government people are out on holiday, bunches and bunches of states have also moved to tax things. So in October, just a couple of weeks ago, we had 11 additional states go live with Economic Nexus rules. Similar, but not necessarily identical to South Dakota, meaning that if you sell e-commerce into these states, even though you're not physically present, you have an obligation to collect your tax. So this trend goes on. November, we have a bunch of more states coming alive. December, we have a few others. January, a few others. So I guess that leaves the question, what states haven't done anything yet? Well, pretty much only a small handful. Tennessee has a court case of their own that they're working through. Texas is working through a regulation. California just had a hearing last week and is planning on doing something. And then below here are the states that haven't done anything yet. I would strongly suspect that as we turn the calendar into calendar year 2019, the rest of the states that haven't done anything will do something that taxes e-commerce. Essentially, what e-commerce sellers are facing is a situation where they're going to have a sales tax collection and remittance liability in a majority, if not all, the states that impose a sales tax, probably the early part of next year. Okay, so that leaves the question, what as a seller should I be doing to get myself ready? And that question will remain unanswered. No, here we go. So first of all, you need to think about not only your collection requirement, but the act of registering for sales tax, for filing sales tax once you collect it. Because the worst thing you can do as a seller, well, maybe not the worst thing you can do, but from a sales tax perspective, the worst thing you can do is you collect tax and don't remit it to the government, because that's considered fraudulent. You don't want to get yourself involved in tax fraud over sales tax. So think about, one of the things you should think about is, how do I register? Because you have to register in all these states, and sometimes the questions they ask you to register are pretty intrusive. So think about registering. Think about how you're going to file, because once you collect, you have to file. And think about how you're going to remit that money directly to the government. And filing is not easy, and filing is getting harder. There are a bunch of states that have, a small handful of states that have created new filing forms that are really, really, really granular and what boxes you have to put money in. So think about filing your own income taxes in 50 states, and that's not quite as complicated as sales tax filing, but sometimes it's getting closer. But fortunately, you do have simplification options if you're an e-commerce seller. For example, in most states that are members of the Streamlined Sales Tax Initiative, and that's 24 of them, you can file a simplified electronic return. It's a far simpler sales tax filing than the standard sales tax filing, like 7 or 8 boxes. It's really, really easy. Alabama, Louisiana, and Colorado, which, if you know anything about sales tax, are the hardest states to collect and file in, they all have simplifications for filing that are part of their approach to taxing e-commerce. So be on the lookout for where you can take advantage of filing simplifications. Now, of course, I work for Somos, and Somos offers a tax determination and remittance engine. So it would be remiss of me not to talk about what you could look for if you're thinking about adopting a technology solution to make sales tax manageable. The Supreme Court, in its decision, said that there are indeed affordable and manageable compliance solutions out there, and I have to think in the majority, the 5 justices that decided to overturn Quill, in the back of their mind, they knew that technology made this possible without causing chaos. So when you look for a technology solution, think about whether it's sound. Is it backed by a team of people that know sales tax and keep the solution up to date? Does it collect and remit tax in all the jurisdictions you are in today and all the jurisdictions you're going to be in tomorrow? Does it support the products you sell, because what you sell may be taxed or exempted depending on state law? And is it scalable? Can you easily integrate a filing solution or an exemption certificate solution into the engine? All really important things to think about. Okay, next question. Will the US Congress come to the rescue and pass a law that puts a damper on this thing? I almost feel kind of silly asking the question whether Congress will come to the rescue. The answer is, I don't know, but right now it's looking like not so much, at least not until after the midterms today, right? There are 2 bills out there in Congress that would put a little bit of a damper on these things, but those bills are still sitting in committee. They haven't done anything yet. They haven't moved an inch legislatively. Congress had 20, 30 years to address e-commerce taxation and do something that the Supreme Court ultimately had to do themselves. They haven't. So there's really right now no reason to believe that Congress will step into the breach and do something here. So I think it's fair to say that these requirements are here to stay. Okay. Now, I don't know how many people out here sell both direct and through marketplaces, but what we're seeing is that in conjunction with enacting these laws, a lot of states are also enacting marketplace facilitator laws. And essentially, what these laws do is they look to consolidate sales tax. So what the states are saying, in one way, shape, or form, is that if you sell through a marketplace, it may be the marketplace that has the obligation to collect and remit tax for you, but what's not clear is how that's going to work. As a seller, do I have to keep track of that? Do I report those as exempt transactions or not? If the marketplace gets it wrong, do I have sales tax liability for that sale? Because if you get it wrong, you owe audit, penalty, and interest. Or is it the marketplace that accepts that liability? What types of marketplaces have this requirement? Is it all marketplaces? Is it just some? What do the marketplaces have to do to get that? And the fact is, all of that is unclear, but I know from talking to states that states like these because they do make sales tax simple. So I suspect we're going to see more marketplace-related statutes come on the books over the next year. Hopefully, and as a provider, we're working to make this happen a little bit, that there's some clarity around what those requirements exist. So very quickly, I'll go through, no I won't, I'll turn it off. Very quickly, I'll show you that there's a bunch of states that have or are about to enforce marketplace rules. So I know people are trying to get some shots. I will absolutely send you this deck if you So, next question. Are sellers from outside the United States required to comply? I don't know if anybody here represents or works with sellers completely and totally located outside the United States, but the answer to that question is yes. Now, whether there's a practical ability to enforce or to collect this tax from these sellers That remains unclear, whether states will have the energy or the excitement around, well, maybe traveling to Italy and collecting from an Italian seller, or to Japan to collect from a Japanese seller. But think about a couple of things before you decide, for an international seller, I don't need to worry about it. Think about your reputational risk. Think about where you might plan to expand later. Do you want to move yourself or open up a warehouse or a distribution center in a state that considers you a tax cheat or already has levied against you, even though they can't enforce it today? There are serious things global sellers need to consider before they dismiss the implications of South Dakota v. Wayfair. And in fact, when it comes down to it, they really shouldn't dismiss it. It's a real obligation. It's an obligation that exists in the rest of the world, and it now exists in the United States. Okay, I had to move pretty quickly through those slides, but does anybody have any questions? Yes? You know, it's funny, because I thought this was going to mostly be a retail audience, so I took that slide out of my deck. But you're right. You have to, there's nothing in Wayfair that changes your requirement to collect and receive certificates from your sellers, from your customers, if they're exempt customers. So today, if you make sales, let's say you don't have a Nexus in, let's say South Dakota, right? And you sell to exempt buyers in South Dakota, agriculture, mining, manufacturing, whatever, you have an obligation to collect certificates from them and maintain them in the exact same way you would today in New Jersey. There's nothing that changes that nexus. In fact, in a lot of states that have that $100,000 rule, you actually count your exempt sales. So even if you make only exempt sales into a state, you're technically obligated to register and collect for tax in that state. Might you decide to wait a little bit before doing it? Possibly. But even if you do that, I heard a consultant from Grant Thornton last week talk about this. And what she's encouraging her clients to do, even if they're not ready to collect, if they make a lot of exempt sales into a state, they should at least be getting the certificates. Because if you get the certificates and you're not registered, and you only made exempt sales, then you're going to be protected liability-wise in the end. Technically, you should have registered, but it's a no liability. Okay, so I'm being told that I need to wrap up. I don't know, was that a half hour? That was pretty fast. But I'm going to be at the Somos booth for a good part of the morning and an early part of the afternoon today. If anybody has any questions about the ramifications of Wayfair, I'll do my best to answer. If I can't answer, I'll take the question home with me. All right? All right, thanks very much. I really appreciate your time.